Hi everyone, and welcome to today's webinar. My name is Catherine Bowden and I'm in the Community Legal Education team here at Legal Aid Queensland. I'd like to start by paying my respects to the Turrbal and Yagara people as the First Nations custodians of the land where our office stands. I'd like to welcome you to sorry, we're having a slight technical difficulty with our presentation. All right. I'd like to welcome you to Domestic and Family Violence, Pathways to Safety, and how Legal Aid Queensland can help. We have two presenters with us today. Kath is a social worker in the Violence Prevention and Women's Advocacy team, and Lindy is a senior lawyer in the Violence Prevention and Women's Advocacy team. Before I hand over to Lindy and Kath, I'd just like to run through some housekeeping slides. This webinar and the future video recording is for community legal education purposes only. It will be recorded and we will later be offering captioning available on our YouTube channel. If anyone's having technical difficulties today, the hosting website GoToWebinar do have a support website that's on the screen now. I'd like to invite you to download the handouts. We have 3 handouts. One is the presentation in case you'd like to download that and follow along. We also have Legal Aid Queensland's guide about how to apply for a domestic violence order and the 2020 domestic violence guidelines. Now, the webinar will be going for around 1 hour today. The first 40 minutes is for the presentation, and then we'll have time for Q&A at the end. Thank you to those who have already sent through some questions. We have form responses to those, and we will get to them during the Q&A at the end. So please hold any questions until we invite you for those. All right, now I'm going to be passing you over to our social worker, Kath, to get started on the webinar, and she'll soon be joined by Lindy to go through the presentation as well. So Kath is just going to share her screen with you and catch up to the presentation slides to go through what she's going to be discussing with Lindy today.
All right, thanks so much, Catherine, for that introduction. My name is Kath. I'm the social worker in the Violence Prevention and Women's Advocacy team. Our senior lawyer, Lindy, has been held up with a court commitment, so hopefully she will seamlessly slot in with us as soon as she is able to. And until then, I will muddle my way through. So what we're discussing today is essentially how you can connect clients with legal aid assistance, particularly around domestic and family violence matters where they need assistance. Now, all of what we're going to be talking about today is Queensland-based. Each legal aid across Australia has different teams and different access corridors, so please keep that in mind if you're supporting clients in different states or territories. Some of the information that we'll go through as well today is only Brisbane-based, but we'll flag that when that happens, just so that you can be aware for everyone who's attending outside of Brisbane. But yes, essentially we're going to be talking about what the easiest access points are for legal aid assistance. So Legal Aid Queensland provides assistance across a whole range of areas. There's a lot of detail on our website as to each different area and what we do and we don't specifically provide assistance around. So please have a look there if you're wondering about legal assistance we can offer outside of the domestic and family violence area. We are also going to be primarily focusing today on the supports that we offer for persons who are experiencing violence, whether they are the aggrieved or the respondent in a legal proceeding. But bear in mind that Legal Aid does also offer support to those who are using domestic and family violence, whether it be in civil, family or criminal proceedings, and we always encourage those clients to link in via our call centre. So we'll be going through those access points in a moment. So as community awareness rises around the behaviours and attitudes that contribute to domestic and family violence and constitute domestic and family violence, not only are more people reaching out for support, but we as workers and community members are learning more about how we can best recognise domestic violence, safely respond, and then act to enhance that safety. So Legal Aid has a commitment to taking domestic and family violence very seriously. So we do work with a lot of clients who are experiencing violence, but also with clients who are using violence, and we aim to enhance safety in all of our client work. So we take domestic and family violence seriously because we know that 1 in 4 Australian women and 1 in 13 Australian men have experienced at least one incident of violence from an intimate partner. And on average, 1 woman a week in Australia is killed by a current or former partner. We're learning a lot from the various research sources across the country, so the Institute of Health and Welfare, the Institute of Criminology, as well as the ABS, but also the Domestic Violence Death Review findings from the various states across Australia and what those reviews are showing us. So Legal Aid is also committed to making sure that we're up to date with what our risk indicators are. Welcome, Mindy. So the data and research also tells us that there are distinct gender patterns in the perpetration and the impact of domestic and family violence. So we understand that it's important that the overwhelming majority of domestic and family violence is perpetrated by men against women. So a gendered lens is important and helpful when assessing and identifying risks. However, there is of course diversity of experience in DV, which is particularly important when working with family violence or with clients from LGBTIQA+ communities. As part of our commitment to taking domestic and family violence seriously, we do have a new framework that we developed in collaboration with the Queensland Law Society in 2020. So this is a number of practice principles that we have to guide all of the work that Legal Aid is doing in this area. So there's a copy in your handouts. We do also have this on our website. So
I'd love to tell you more about it. So this is a document or a framework that we produced in consultation with the Queensland Law Society. Prior to that, each organisation had their own sets of principles and frameworks that they use to really assist practitioners, both legal and non-legal, in working with people who are experiencing domestic violence or using domestic violence. And we, as I said, launched this one in May of 2021, and it covers a wide range of principles. And Kath's mentioned a couple of those already, and I forget where she was up to, but I'll start again. It's really about improving your understanding. So when you're working with people in this area, it's very important that you have a good understanding of the social science. It's about promoting safety, prioritising safety, not only of clients, but also of ourselves as workers in the area, facilitating the empowerment of the clients we work with so that they can make their informed decisions, promoting accountability of behaviours that we see in this sector, in this space, communicating with clients respectfully and appropriately, respecting diversity, whether that be cultural or otherwise, and one of the most important things from my perspective is collaborating with the other stakeholders that we find in this space.
That was perfect, Mindy, because I hadn't actually started the details. Thank you. Well timed. All right, so on to the nitty gritty of what we're trying to knowledge build a bit around today. So there are a number of access options to support from legal aid in domestic and family violence matters. These are the 5 key ones that we're going to be talking through today and hopefully clarifying for you in any confusion that you may have. All of these options are publicly available and you can share these details with your clients. And we're going to go through each of them as to what they really aim to achieve, but why they might be the most appropriate access points for your particular client. All right, so the first one is the Legal Aid Contact Centre. So this is where all of the phone queries for legal aid come through and are fielded by our contact centre workers. So these workers assess the legal issue at hand, the level of assistance that may be required by the client, and then allocate that client to the most relevant legal team for assistance. So these triage workers, while they are very legally skilled in assessing those issues, they aren't lawyers, so they cannot provide that advice directly. So this access corridor is best for clients who do feel comfortable to explain their legal issues and are able to make that call. Clients who may have multiple legal issues across a number of different areas. So they might have a family law proceeding, but also a criminal law matter. So then that worker can help them assess which one is the most pressing and where they should be getting that assistance from first. It's also helpful for clients who really aren't quite sure what the legal area actually is. So they may have concerns about their children's safety while they're in the other party's care, but they aren't clear whether their particular circumstances would be most best captured by family law or child protection or domestic violence legal advice. Or it could also be clients who are at the very beginning of their legal proceeding and are seeking general advice and information about the first steps and their beginning options. So clients who are calling through to the call centre will speak with that worker who will triage them. It's unlikely that they will receive legal advice immediately, so they will go on a list or be booked in for an appointment. However, if their matter is urgent, the call centre or contact centre, can be doing everything that they can to put them in touch with a lawyer as quickly as possible. Option number 2, Judy.
So now we're looking at this second option, and that is contacting our team directly. So this is people that don't come through the call centre. They may have already had some contact with a domestic violence service or heard about our service or even used our service before. So that's our direct number that goes into our general admin section within our team. And they will do, the workers there, again, also very highly trained. They're not lawyers, but they can triage for the criteria that we apply for assistance from our team. They'll do the intake and they'll add that client's details, name and telephone number and any safety aspects or availability to a SharePoint, and we will then provide a one-off advice as appropriate. It may also be that we can provide some minor assistance or task assistance, as it's often referred to, and we'll deem that as appropriate, we will do that work. So why is this option the best one for your client? Clients for this service are able to self-refer, so they don't need to come in through any other particular pathway or be referred by another service. And it's really about that one-off advice about how to start the proceedings or what are the next steps for them in those sorts of areas. So domestic and family violence needs to be the key presenting feature of their legal problem. And we can then give advice around the other surrounding issues. As Kath said, these issues are often multi-dimensional, but for us to be involved, domestic violence needs to be the key feature. So next I'd like to talk to you about domestic and family violence duty lawyer service. I'm sure I'm looking in the wrong spot, but I should be looking at the camera, shouldn't I?
And we'll go into more detail about the duty lawyer program a little bit later. So this is just a brief summary about why you would be linking in with this as your client's initial access point to legal aid.
Okay, so this is a situation where your client is seeking advice about a matter in court on that day. So they're needing to access advice, advocacy, representation on the day. It's not about matters that aren't on the list. If they're needing help with that, there are other services available. They don't need a referral. They can just turn up at court on the day. And obviously with any legal matter, it's very, very important to bring all your paperwork with you. Why would you be choosing this option? And that is if you've got a client who has a mention before the court that day.
Oh, sorry.
And they're needing legal advice about it.
Okay. So another avenue of how we assist in domestic and family violence is with our application assistance program. So this program is for women who are wanting help in completing either an application for a protection order or an application to vary a protection order. We are only able to offer this assistance for women who are filing at the Brisbane Magistrates Court. So for other Magistrates Court, some of the regional DV services may be able to assist, or community legal centres. So please encourage your clients to either connect with those organisations to discuss what options may be available under their assistance, or to call through the contact centre in case general phone assistance can be arranged for them, or to utilise as well separately the new Legal Aid Guide on completing that application, which we'll also discuss in a tick. So this program is run by our support workers, our domestic violence prevention workers, so it isn't legal assistance. So that means that this program is really best for clients who are requiring general information in completing the forms and where their grounds or their reasons for the application are relatively straightforward. So we provide guidance around what details are helpful to include and under which question, because I don't know if you're familiar, but the form is very long. And we also discuss the additional conditions that may be relevant and helpful for that client in their situation. Depending on our capacity, because it is a drop-in service, we can provide then and there assistance for that client to be going through and filling out that form. We don't do drafting. So drafting is a legal service where the client would tell their experiences and then it would be turned into the details for that application. Our work here under the Application Assistance Program is designed to support the client to put their own story into the application in a way where all of the relevant details are included and are presented in a helpful way for the magistrate. So if your client does require that additional assistance beyond what that program can offer, or they have compounding vulnerabilities such as relying on an interpreter, we recommend either applying for a grant of aid so they can have that hands-on lawyer assistance to do that drafting for them and to attend court with them. But if they have been declined for legal aid and they cannot afford a lawyer themselves, of course, we will do the absolute best that we can with those clients. But just in terms of what the best access points are, it may be better to explore those other avenues first. We also welcome calls in advance. So if you or if your client has questions about whether this is the right access point for them, our direct number is up on the screen there. So you're welcome to give us a call in advance. That's also helpful in terms of preparing the client in advance for anything that might be helpful for them to pull together, such as supporting documents or start drafting out some timelines around what their experiences have been. Our workers do also prioritise discussing the safety of applying and whether the application may actually elevate their risks and what strategies can be used to best mitigate those, because we know that legal proceedings do escalate risk of serious violence, but also around intimate partner homicide too. So we take that very seriously. We'll step through the registry filing process and also plan for their safe attendance at court for their future mention dates as well. And speaking of our future mention dates, that's the second part of our domestic violence prevention worker assistance. So our workers are present at the Brisbane Magistrates Court each day the DV court runs. So here in Brisbane, we work alongside the Violence Prevention and Women's Advocacy team lawyers in their duty lawyer role. And our role here is to provide information, support and assistance to all women, so whether they are the aggrieved or the respondent. And we support women for mentions, contested hearings and breaches, which is slightly different to what the duty lawyers do, and we'll go through that in a tick. So we're giving information about the court process and what to expect, including what the duty lawyer may be able to assist them with that day, just around that expectation management and hopefully making the process make as much sense as possible. We do a brief risk assessment as well. We discuss strategies for safety while the client is at court, strategies for actually leaving court safely and getting back home or getting to where they're staying, but also for that period following that court date when we know that risk is likely to be higher. And we provide referrals to support services where that might be relevant or helpful. At the Brisbane Magistrates Court, similar to a lot of the courts that run DV mentions across the state, there is a safe room that is available, but we do also, and that's for women, but we do have separate office spaces that can be allocated for all of our guys, gals and non-binary pals who might need a separate safe space as well. We work closely with all of the stakeholders, so the respondent duty lawyers, the security, the registry and our court volunteers. So everyone is really prioritising assessing that risk and responding safely as possible, not only in terms of the work that we do, but also how the floor is laid out. And so safety is always front and centre when we are at the DV courthouse.
Absolutely. So the fifth option for accessing assistance with family and domestic violence issues is by way of a grant of legal aid. So this is in the situation where your client has a clear legal matter or a continuing legal matter. You know that advice is not going to be sufficient. The duty lawyer service can only take matters so far. We'll look at that in a little more detail later on. And you know your client will need to have a solicitor appointed to assist them further. For example, with drafting, as Kath was saying in relation to previous slides, the application assist program can really only take the matter so far. It's clear cut. If the application requires that the addition of drafting circumstances into a legally admissible document, then it may be best for the client to be represented at that stage. So in that instance, an application for legal aid, a written application is required. So why would you be going down this pathway? And as I said, if you're required to draft those initiating applications or affidavits and response materials in order to continue with an application that's already before the court, representation in a lawyer-assisted mediation. So legal aid offers that model, unlike other mediation models where clients are legally represented in the process. Or representation before the court, and that's generally in a contested matter where it's clear to the court that the other party is not going to consent to the order, they're opposing the application, not consenting, and the client requires ongoing legal representation with that in either the Magistrates Court or a family law matter in the Federal Circuit Court. So that's where we can assist.
So I just thought we should clarify now that we've come to the end of those 5 different access routes for assistance around domestic and family violence legal matters with legal aid. The grant of legal aid is the only one that has the financial eligibility requirement and those tests as well. So we will go through that in a little bit more detail. But access to that one-off advice directly through the contact centre or the VPWA line, duty lawyer assistance, the application assistance program and the court assistance, there's no means test for that. The eligibility will depend on whether we are the right fit for their legal matter. So that's an important distinction to make between 1, 2, 3, 4 and then number 5 there as well. All right, so duty lawyer, what are the ins and outs of how this works, Cindy?
Let's have a look at duty lawyer service. So it began back in 2015 and as you may or may not know, the Judy Lawyers Service really came out of the recommendations of the Not Now, Not Ever report, Quentin Bryant's, and it was seen as a gap in provision of legal services to clients who were dealing with these matters. And the service really just has gone on to improve, I would say, exponentially. I was there in Southport in 2015 and had the honour of participating in the training of Judy lawyers back then. And it's, as you can see, has grown considerably over the intervening 6 years. And there are differences in the models. I think there's another slide where we go on to explain that in a little more detail. But the specialist model is unique in that we actually have allocated specialised magistrates who have done training in that area. Similarly with the registry staff, they are specially trained. And importantly, the courts are funded to perform that specialist duty. And those courts, Southport was the first, and then those other locations have been added as they've been funded by the state government over the years. So we currently have those 5 locations. And then the enhanced model that is in a lot of those other courts that you'll see listed there, including the Brisbane court where Kath and I work out of routinely. So that's slightly different in that they're rotating magistrates. You may get magistrates who are not necessarily specialised in this area, and the level of assistance that we're able to provide does vary from court to court. There are lots of other, I think there's 33 other locations from memory where duty lawyer services are available, but they don't necessarily provide that level of assistance.
Yeah. So there is a full list of where all of the legal aid provided or legal aid supported duty lawyers, domestic violence duty lawyer services run across Queensland. And if you've got particular questions around what level of assistance is available in the magistrate's court that your client would be going through, you can contact that legal aid office directly to inquire how that program is operating, just so that your client can know what to expect in advance.
Yes, because it does vary from court to court. So let's look at the actual role. What is a duty lawyer expected to do to assist your client? Well, they start by explaining the court process to the client. They're going to cover the outcomes that are likely in the court that day, whether the matter has a good chance of being successful, and most importantly, they're going to be explaining what the respondent is likely to be advised about by their counterpart, the duty lawyer's counterpart. The duty lawyer must seek appropriate conditions, and that doesn't necessarily, well, let me say, part of the role too is to ensure that the wishes of the aggrieved are heard and put before the court. So the conditions sought in an application, for example, a police application, may not necessarily be sufficient. So it's important to make that assessment. Is the client safe? Are further conditions required? And then advocate for that client and seek those extra conditions. May well be the reverse. And again, we need to be respectful and appropriate in those circumstances and put the wishes of the aggrieved before the court. It's important, if it's possible, and this is again part of those recommendations from the Not Now, Not Ever report, that we minimise our clients' exposure to the domestic and family violence court system. And if it's possible to negotiate a final order on that first return date, then that is by far the best outcome for the client, because they don't need to come back to court. The respondent doesn't need to come back to court, and we're along that track. They're not really dealing with the client's safety and ensuring compliance and a cessation of those behaviours. appear for the client if that's part of the model. That means represent the client in the court, and after court or before for that matter, make appropriate referrals in relation to housing, crisis counselling, health, mental health, all sorts of issues. There are support services available, and whilst we don't often have the time to actually assist with the completion of a legal aid application form, we certainly have them available, and we try and ensure that they are appropriately flagged so that they come back to the lawyer providing that assistance, and then we can fast track them through to our grants division for an assessment, and generally the file will then come back to our team or to that particular legal officer who's been involved. So again, as part of those recommendations of the Not Now, Not Ever report, the client's number of traumatic experiences in having to retell their story is limited as best we can limit it.
And the duty lawyer assistance is also limited to those that mention stage of the application. So they're unable to assist with a contested application or with a breach.
Yes.
So if that happens for your clients where they do have a contested application or a breach, we really do recommend either applying for legal aid or engaging a private solicitor as quickly as possible, just so they can have that assistance in preparing all the materials that they need. Alrighty, so you know that you need to apply for legal aid. So we're just going to go through the nitty-gritty of how to actually help this process along as much as possible, because this is a common access route, particularly where DV is a concern or an issue that's part of the legal matter. So we recommend carefully completing this form. So it is a very lengthy form. There are a lot of indicators throughout the form of where you need to attach supporting documents. So an application cannot be assessed fully or approved unless all of those relevant documents are actually sent through. So that is very important. There is that helpful checklist on the cover, which is that orange box there, but there is also little paperclip symbols throughout the whole form that flag, oh, I might need to attach something at this point. So go through that carefully with your clients. A grant of aid, you can apply for an entirety of a legal proceeding or part of a legal proceeding, so it is necessary to be clear as to where your client is up. Like we flagged before, when you're looking at applying for a grant of aid, your client should already have a clear idea about what they're actually needing that legal assistance for. Once the legal aid team has received the application and all of the relevant attachments, they go through it to confirm that it meets the tests that need to be applied to every single application they receive. The timeframe for approval can vary significantly. So it can be hours for an incredibly urgent matter. So that may be where a small child has been removed by the other party and there are concerns for the risk that that child would be at. Or it can be weeks if there's an application to bring in new proceedings and there's not current risk concerns, or where the next in court date in that matter is sometime in the future as well. So there is a lot of discrepancy as to how long this
or if there are gaps in the application. And that's why, as Kath said, it's so important to put as much information in as possible. Absolutely. Because that can lead to delays, and the grants officers are just as busy as we are. Indeed. And if we can help make their job easier, there's a grant and we can then help your client.
Yes. So if your client wants you to be able to speak with legal aid about their application on their behalf, you will need to submit an authority to discuss the grant of aid form that your client should have signed as well. So that's available at that link there at the bottom of that slide, or by Googling authority to discuss grant of aid, Legal Aid Queensland. It is the top hit that comes up under Google with that.
So when we're looking at applying for legal aid, you would expect there to be some tests that are applied, and that is the case. That part of our mission statement is to assist Queenslanders who are financially disadvantaged. So that's certainly part of our eligibility tests. So not everybody's going to get a grant of legal aid for representation, it's going to be the most significantly disadvantaged in our community, generally speaking. So if you're applying, you need to ensure that sufficient information is provided and documentary evidence is provided in relation to your client's income. And that will include, naturally enough, any Centrelink benefits, wages and salary, income from businesses, payment from trusts or rents or board, and Centrelink statements. Clearly, a statement of their income will assist in child support payments they're receiving. Generally, every type of income, our grants officers need to know about that. Now, there are very few matters where that means test is not applied, and that relates to independent children's lawyers, separate representatives in child protection matters, and if we're representing children. If children are making an application for legal aid for representation, direct representation in a matter, then they are not subjected to that means test.
So our other test then is our merits test.
It is. So not only does a client need to be eligible financially, but they also need to have the sort of case that is covered by our guidelines and priorities that are set by governments, but it also needs to be a fairly good case, a case that's going to be likely to succeed. And sometimes that people are a little surprised about that. They expect just because they're financially eligible that they're going to be provided with a lawyer to run any case they want. That's unfortunately not the case, because we're spending public monies, and that links into that third part of the merit test there, that we need to be careful about that expenditure. If the costs are warranted, then a grant of aid will be approved. And then we also need to look at that second aspect there. Is it the sort of case that if you were paying the legals yourself, you'd be happy to pay? So that's a prudent, self-funded litigant. And again, that gives our grants officers a pretty good indication, if they can satisfy those three tests, that that's going to protect us from public criticism really about the way we're spending those funds.
Okay, so for anybody who's familiar with the legal aid application form, you will know already that it is quite a lengthy document with lots of boxes to tick. And then there is this very lengthy question 18 at the very end that generally says, tell us about your legal problem. So this is actually one of the most important questions to provide a detailed and thorough answer to when you're assisting a client to apply for legal aid. This is where legal aid will get its understanding about what the legal problem is and why legal aid or legal assistance is needed in this matter. So we need to understand the applicant's circumstances, and this is that opportunity to provide the context for any of the answers that have been provided earlier on the form. So providing context for financial situation, providing context as to the impact of the domestic and family violence. So really going through clearly who is the other party, what are the safety concerns, if it's a parenting matter, what are the current arrangements that are happening at the moment, and why aren't they working? So is it because it's no longer safe, or there's been a practical change in circumstances as well? So this is really important to complete, and with a thorough understanding with legal aid, legal aid will be much more able to assess those merits tests as well as the means test as well.
And sometimes, just adding on to that, that the application can come from one of those other options for assistance. For example, if your client has received legal advice, that may result in them completing a legal aid application with a notation that they've received advice, and that we can checklist that claim or that legal issue as warranting closer scrutiny by our grants officers. Similarly, with the Judy Lawyer Service, we can flag that we've assisted that client and we think there is merit for the application to proceed, so long as they're financially eligible.
So that would mean that then the client is completing the form to provide all of their financial details, all of their relevant legal documents and attachments, but they don't need to complete all of that nitty-gritty detailing questions.
That's right, yes.
All right, so if you're lucky to have your grant of aid or application approved,
then you're allocated to one of, well, let's step back a bit. There's going to be written notice that there's an approval of a grant of aid for a specified or finite legal matter or a step in the process. It may be that you've given a grant of legal aid to commence proceedings or attend a mediation, and then once that step's completed, you may be required to apply for an extension of legal aid. But generally speaking, if approval is granted, then either an in-house practitioner like myself will be notified, a file will be opened, and will then have that lawful authority to commence work for a client, or it'll be sent to one of the many preferred suppliers, private lawyers who do work on behalf of legal aid, so they're paid at a set rate for the work that they do. The client, of course, also has obligations, and they need to keep us up to date with their things like address, phone number. You'd be surprised. Sometimes it is very difficult for us to make contact with a client, and we're ready to go with a file because we've got a grant of aid and those details are not kept up to date. So they also have an obligation to provide timely instructions. If we ask for instructions about the progress of a matter, that needs to be timely. And of course, they need to follow our advice and follow the directions of court. If we have a client who's contravening court orders and not following our advice, then there can be serious consequences that can result in a grant of aid being terminated. That's a very unusual circumstance.
Yeah, and the context of that is often because that's coming under that merit assessment. So non-compliance with a court direction does then come into those merit granting principles that you went through on the previous slide, right, Lindsay. So it's important that if your client is concerned about the legal advice that they have received or the impact of a proposed order that's being made, that they are discussing that directly with their lawyer, because we want to make sure that we're creating a situation where clients are actually best able to follow the legal advice that they've been given. The lawyer is best understanding the client's circumstances, but also that the client understands what's happening with that court order and supports are put in place to help them comply with those directions.
Exactly.
And appealing?
So in the event that there is a termination of aid or it's refused right from the outset, we have appeal processes built into the system where you can be of great assistance to clients by writing letters of support, further explanation. If, as I said before, there are gaps in the application and that's resulted in a refusal or a termination, just to clarify the client's situation. There's a time limit, 30 days from the date of the decision. So very important if you are assisting with an appeal for a client that that's done in a timely manner in compliance with that time limit.
Okay. And speaking of forms and legal processes, we're now going to talk about another very important form and legal process, which is the applications for those domestic violence protection orders. So the information that we're going to go through is essentially to help you best provide support and information to your clients who may be considering this as an option to help enhance their safety, but also so you can best prepare them for what is likely to be involved. So Legal Aid Queensland has recently updated our how to apply for a domestic violence order booklet. So we strongly encourage you to have a look at this if you've got questions around this process. It is very detailed, but you can also provide copies of this to your clients who are comfortable to read English and also where it's safe for them to receive those resources. It includes examples about what information can be included in those forms as well, so it is quite practically helpful. too.
And information that we will be talking about in the next few slides is really included in that booklet, and we strongly, highly recommend that booklet to you. It's really an excellent resource for you and your clients when you're assisting them.
And that's not only because Lindy and I were both
We have heard it from others. So let's have a look at the requirements for an audit to start with. So the legislation requires that there be a relevant relationship. So the types of relationships are listed there. It can't be domestic violence order against your next door neighbour. You must have had that intimate domestic relationship, and that's really the context then for the acts of domestic violence. The court has to be satisfied of that is the relationship, then that there has been an act of domestic violence, and then the order itself is necessary or desirable. So it's a very subjective assessment. It's also a discretionary assessment for the court, but it's there to reduce the risk of future violence within that specific relationship.
It's also important to note that even though the family dynamic varies, like we've specifically noted, that's for where both parties are over 18. So if there are concerns for a child's safety while they are in the other party's care, domestic violence order is unfortunately not the right proceeding, because the court will be focused on what's happening between the adults. Children can be named on an order if there is concern between those two adults, but they cannot be the primary aggrieved or the primary respondent if the child is using violence against a parent or sibling.
And I don't know if we mentioned it in the slides, but children themselves can be litigants if they're in a personal, intimate relationship with each other, boyfriend, girlfriend, and there are acts of violence arising out of that relationship.
Yeah. So where to start? So breaking down the legalese, a DV1 is the new application for a new protection order. A DV4 is an application to vary an existing order. So it's important to have the right form, but it is also important to consider the safety around applying at all, but also then each process that's involved in that application process as well, like we've mentioned throughout the presentation, safety in attending court. So a couple of the key things to consider around this is that if the respondent does not know the aggrieved address, do not put it on the application paperwork, because the entire application paperwork will be provided in full to the respondent. If it's important that the aggrieved address is kept confidential, on the same court's website, listing where there's all of the DV forms is the confidential address form. So they need to put their address on that. So the court has a copy of that, but do not put it on the application form itself, and be particularly mindful that if the aggrieved is naming children or other parties as named persons, to not unintentionally put their address next to those people as well at that different point in the form. The other important one is the court safety form. This is for safety actually attending the court building. So that can be filed with the registry with the application or after receiving a mention date. So this can allow the registry to work with the court security and the domestic violence court support workers who may be attending on that day to work out a plan to enhance that safety as best as possible. So common options include early access to the court building, a separate access if that's possible at all, or a security escort into the safe room once they have arrived at court as well.
So next we'll look at the application process itself. That's applying for a protection order rather than, we talked about applying for legal aid. So the first thing to assess is this a matter that is really straightforward? You can fill in the DV1 or the DV4, depending on whether it's a first application or a variation application. Is it straightforward? Can you do it straight away? Is time of the essence? Do you need the order for that evening, for example? Or is it a little bit messier, a bit more complex? You need some legal advice. And this is the process that we recommend that you step your clients through. Then look at what support they have. Now, we know that often these matters occur in a vacuum behind closed doors, that there often is no actual evidence that these acts of domestic violence have occurred, but if there are, then it's certainly going to be of assistance to the court. There might be previous domestic violence orders, there may be photographs of injuries, there may be medical reports, screenshots, text messages, Facebook downloads. There could be parenting orders. That's actually a legal requirement. If there is a parenting order, you must attach it to your application so that the court is fully informed about that.
Sorry to jump in here, Lindy. We're just sorry to jump in, Lindy. We are getting a little bit pushed for time. We've got 10 minutes left. We might open up to questions so people can start sending those through as you wrap up the last few slides. And as they jump in, I'll let you know and we can start answering them at the same time. Thanks, Lindy.
Catherine, so we might skip forward then to the particular conditions then.
And the first condition, whenever a court makes a domestic violence protection order, is that the other party be of good behaviour and not commit any acts of domestic violence in relation to the aggrieved, or if there is a named person for a child or an associate, say a family member, the same mandatory condition is made in relation to that person. That's why it's called a mandatory condition, because it supports the order. And then in addition, we need to assess what else is going to be necessary or desirable for this client. Are further conditions, further protections necessary? Do we need to prohibit the respondent's behaviour in relation to coming to her home, contacting her, locating her at any other place, for example?
And also the urgent.
Yep.
Urgent and temporary orders as well. So there's 2 different ways or 3 different ways if you consider police protection notices where this would be relevant.
Yes, yeah, and it's important because it kind of goes against the grain a little bit. Orders can be made in the absence of the other party, but if there's sufficient and appropriate evidence on the face of the application, which is a sworn document, then the court can make an urgent order in the absence of the other party. So you can file that day and have an order that afternoon, which is really important if you've got a client who needs to have the other party ousted from the property to protect herself and the children. That can be done ex parte, just without the other party being present. Now we'll talk a little bit in relation to variation. So this is an application to change the conditions that are already included in the order. And we unfortunately see a lot of clients who are seeking to change an order. Orders made for a period of 5 years, and that's for a very good reason, again, stemming from the Not Now, Not Ever report. Time doesn't permit us to go into all of that, but make sure when you're assisting clients and they're seeking variations that there has been a genuine change of circumstances. Any risk issues have been addressed. For example, the other party may have undertaken a men's behavioural change program, counselling, may have seen a psychologist. Evidence needs to be produced to convince the court that it's going to be safe to make those changes.
In the reverse though as well though, the application to vary form can also be used to add conditions. So if risk increases, and it may want to add conditions that weren't on that original order that sustained form, or if they're getting too close to the end of the application period of the order, to extend how long it is in place for as well. So we might pause there. So we've got a couple of questions that we had received in advance that we can quickly respond to. But Catherine, have there been any others that have come through while we've been talking?
Thanks, Kath. We might jump straight to the questions that were already asked, as you mentioned, just to give everyone a little bit more time to ask their questions. So if you do have any questions, now is a great time to send them through to Kath and Lindy. We have got 5 minutes left of the webinar. We probably will go over by about 5 or 10 minutes, so you're welcome to stick around as long as you'd like as well. Kath and Lindy, shall we start with the first question on your list.
Answers here as well, Catherine. So I might give Lindy a moment to still be catching up from her post-court.
Did you say the answers?
So with the query that we had around how legal aid assists the rural and remote clients across Queensland. So we do have a number of legal aid offices that are across Queensland and preferred providers in regions where we don't have offices based. So we can also provide that legal assistance by phone, and with all of the COVID restrictions over the last 18 months now, we have become also quite skilled at providing video call assistance too. So the way that help could be provided to clients who are rural or remote would depend on the level of assistance that is needed, and that would be assessed either by contact with their closest legal aid office or calling through to the contact centre or direct to DPWA. But also would depend on our assessment of the client's safety as well. So whether there's any technologically facilitated abuse occurring and whether it is actually safe to be providing advice via the phone or via a video chat, or whether we do need to be exploring other avenues to facilitate that, such as through a healthcare provider, or thinking creatively around what's accessible for that client. So we do work hard to make sure that our services are accessible, but it will depend on the level of assistance needed, but also those safety concerns too, in terms of how we can best meet those needs.
Okay. Thank you very much for sending in your questions. The first one is, if an initial application, I'm not sure if you're able to read this, is dismissed, then after a matter of months files a fresh application, can this be considered? And the short answer is yes, absolutely it can be, because there may well have been a change in circumstances. Risk can change quickly, and the dynamics of domestic violence, the grounds, may be completely different after a few months. So that's, you're never stopped legally from filing a fresh application. Even, for example, if you accept an undertaking or a promise from the other party not to do certain things, you can still change your mind if there are grounds and file an application. So you can never really contract out of that legal right to file. Then question number 2, again, thank you for sending that in. Can clients file in a separate town for safety reasons? And this is a very common scenario that we see where women are in refuge and need to file in a different town. That's fine, there's no problems with that, and they can access legal support in the same ways that we've discussed during this presentation. They can get advice by phoning, they can apply for legal aid. It's a little more complex accessing the duty lawyer service, but it's certainly available, and we can appear and have you provide instructions by phone, by email. We can seek leave for you to appear by phone. So pretty much anything is possible.
Yes.
You go.
In that instance too, it may be worth considering whether the client does want to actually apply for legal aid, if they may be eligible, because that way they can have a representative in the court in the location that is going to feel safest for that client. That lawyer can assist them in putting together that paperwork, can attend all of those court mentions on their behalf, and then can keep the client fully in the loop about what's happening if the client doesn't actually feel safe to be attending those court mentions as well. So it is always important to consider that as an option, even that early on in the application proceeding too.
The only thing that I would mention there, one word of caution in relation to filing in different registries, if there is an order, for example, that was made in the Beenleigh Magistrates Court, and a client then files in the Maroochydore Court, perhaps doesn't mention the earlier proceedings, that can cause no end of difficulties for lawyers trying to represent in those situations. So generally speaking, only generally, if you've got an order in one court, file in that court. If you're seeking a variation or another order, they have the history, but that's only a general indication. Always get legal advice first.
Yeah. Catherine, anything else that's been flagged for questions or clarification?
You made it.
Thanks, Kath and Lindy, for answering those questions for us. Yes, we do have another question that has come through. somebody is wondering about getting assistance to fill in legal documents. They were not eligible for legal aid, so they are with another community legal centre, and they just wondered if there's any help out there for them to fill in a DV4 form.
So if they're not eligible for legal aid, they can still access that one-off legal advice. The booklet on how to apply for a DVO does include details around that DV4 and that variation. Given that it's a DV4 though, it's very important to consider those points that Lindy mentioned before. So they do need to be able to demonstrate that there has been that material change to risk, or the risk that was identified to the court in the original application. A DV4 isn't an appeal of a decision to make an initial order. It is a demonstration that there is no longer risk present where the order is needed to mitigate
or increased risk and
Correct.
further conditions are sought.
Yeah. So the booklet would be my first point of call, consider if they've met all of those conditions that those criteria that Lindy has recommended. We do also have some additional forms on the Legal Aid website, so that when you go through the Get Legal Help and the resources and things for clients, there is a whole swathe of documents there regarding DV proceedings, and they do include some tips around completing forms. There is also one on self-representing in court and one on completing affidavits as well. So there's a lot there to file through that will hopefully give some of that assistance, but also remembering that you do have that backup of that one-off legal advice over the phone to assist with those matters too.
And whilst it's not always available, on occasion, depending on the vulnerability of the particular client, we can provide minor or task assistance, and that may involve going through the document. It depends because, you know, obviously on those advice days, there are many other people waiting for advice, and sometimes we are very limited because of resources as to what assistance we can provide. But the other thing I want to mention was CLCs. You have indicated in the question that you're now linked with a community legal advice centre. There are some CLCs that specialise in this area.
Yep.
Southport, Women's Legal Service, who have a lot of experienced practitioners who can assist, and Caxton, that's right. So perhaps your client will fall into the target groups assisted by one of those CLCs. That's probably the range, I think.
Yeah. It's also, you know, so he's applied for legal aid Judy lawyer and it was rejected. So the application that we processed, that we went through, that's for a grant of aid only. So like we mentioned, that's not for the Judy lawyer program. The Judy lawyer service is not
means or merit
tested. So it may be that the client may also benefit from just really clarifying with legal aid where things are at with his legal matter as well, just in case there has been some confusion there too.
And just finally, I suppose if it is an application for variation and he attempted to gain support through Judy lawyer service and, you know, was unhappy with the advice that he got, you know, that could result in a perception that he'd been rejected, as it were. But you know, that's our role, is to give advice on prospects of success and likely outcomes in the court. So I don't know if that helps or not.
Okay, I hope that's clarified things.
Very long answer, sorry.
Thanks for that, Lindy and Kath. We have a couple more questions to get through. It is 3 o'clock, but I do invite you to stay on if you have the time for another 5 minutes to get through our final 2 questions and our wrap up. So Kath and Lindy, someone is wondering if the PPN provides immediate protection in a similar way that the TPO does. And would you mind just explaining those acronyms as well for the others listening in, please?
Yes, it does, but only for a very short period of time. And generally, before the court in a very short period of time, and then the TPO will take over from the PPN. So the police protection notice is in place after police have attended upon an incident. The TPO, the temporary protection order, is put in place by a court when the parties first come before the court on that first return date, generally a day or 2 or 3 after the incident that has given rise to police attention.
Thank you for that. Our final question, somebody is wondering if they can put forward a Legal Aid Queensland application and request that their legal assistance actually be outsourced to one of our preferred suppliers, if there's any conflict, if they're requesting a preferred supplier or an in-house legal aid lawyer.
So Legal Aid does do conflict checks. So if there is a legal conflict, they won't be allocated to a provider, whether it's internal or external, where that conflict would exist. If a client or an applicant does have a particular preferred provider that they want to access their support through, they can actually approach that practitioner directly, and that practitioner can advise whether they can apply directly to Legal Aid on that client's behalf. Which would mean then that grants would prioritise that grant of aid being given, that grant of aid being given back to that preferred provider. There's no guarantees, but if you're concerned about a conflict existing with a matter remaining in-house or with a particular legal firm, Legal Aid doesn't allow that to happen. They're very
and certainly highlight in the application, put that, flag that as a potential issue or a potential concern for you.
Yeah.
Thank you, Lindy and Kath. There's all the questions that we have time for today, but if you do have a question and you didn't get a chance to ask it, you're welcome to email us. The email is webinars@legalaid.qld.gov.au, and our presenters will do their best to get back to you. Kath and Lindy, would you mind leaving our audience with just a few takeaways from your presentation today?
Always read the fine print, and also think that a legal response is only one part of the solution in terms of enhancing safety. So there are instances where a legal response may not be what a client chooses that will work best for them. It's really important to have regard for what a client will think in that instance. They are the expert in their situation. We need to be guided by them. Legal proceedings do enhance risks, and we want to make sure that we're managing that as carefully as we can.
Also, it might not be the right response at that time, that once the client's other needs in terms of safety, housing, therapy, counselling, whatever their needs are, then perhaps they can consider a legal response, their legal remedies. That sometimes people think that a legal response is really the most important, or indeed the only response. And the other take-home message is always include your supporting documents with your legal aid application, because that will only result in delay for us in representing you and for you in gaining that representation. So that's probably my takeaway.
We hope that's been helpful and clarified some of how clients can best link in with legal aid assistance.
Thank you very much for your interest.
Thank you, Kath and Lindy. That's been a really wonderful presentation for everybody. We've had a flood of comments, everyone saying that it was really informative and that they really appreciate your time today. So on behalf of everyone, I'd just like to thank you for your presentation and sticking around to answer the questions for us. And I just want to remind the audience that today's webinar has been recorded. It will be captioned and it will be published on our YouTube channel. So please keep an eye out. If there's anything you wanted to go back and revisit, you're welcome to rewatch it. We also have those 3 handouts. If you haven't already downloaded those are the presentation slides and the domestic violence guidelines, as well as our how to apply for a domestic violence order guide. So thank you to our audience for listening in, and thank you again, Kath and Lindy. Keep an eye out for our next webinar, which should be released on Monday. So take care, everyone.
Thanks, everyone.
Thank you.
Stay well.
Bye now.